y'all doing? So at the beginning of the pandemic, John reached out to me and said, oh, we're gonna try this phone thing. And I can remember Chris and Christine and I were all in our conference room on my cell phone, handing it around. So I think half the time our heads were upside down and trying to keep everybody going during the pandemic, trying to keep us going, because since about 1985, when I was 5 years old, and I started practicing law, I've been in court pretty much every business day of my life. And when the pandemics shut the courts down, I mean, all my friends are bailiffs. I have no social life if I can't go to court. It was tough. It was tough for all of us. And then that was a shutdown by the Missouri Supreme Court, the part that shut the courts down. I know that our legislature recently passed a law against eviction moratoriums in the courts, but the legislature can't be over the courts. We have the three branches of government, right? And in Missouri, that's the legislature, the courts, and the governor. So that's not really going to stop the courts from ever shutting down again if the Missouri Supremes feel like they need to. The good news about that is we figured out Zoom and WebEx, and we still do a certain amount of court remote now. So I don't think it will stop again like it did, where it just stopped dead for 2 months and it was horrible. And then, we have different characteristics of different counties around the state and right here. In the county of St. Louis, you might remember, am I bringing back bad memories? You might remember that our presiding judge at the time, Judge Burton, sweetheart of a guy, and apparently, very affectionate towards tenants, because he stopped evictions for a year. He felt that even once we were back in court, first we did court, on Zoom, and then we got back in court, he felt even after that, even after we started having vaccines and, what have you, he felt that he could not let the fragile blossoms in the sheriff's department go out and evict people. Now, I don't know if you've met any sheriffs, but they are pretty hardy guys. And they were upset that they couldn't go out and do their jobs. And really, when we do an eviction, how many people have set someone out in St. Louis City or County? Gone all the way to court, gotten the judgment, put them out. Okay, so what we do now is the sheriff sets the date, you meet the deputy there, you have the ability to change the locks, or you have a locksmith with you. The deputy walks quickly through the dwelling, removes any people, supposedly inspects for contraband like drugs and guns, and you change the locks and the place is yours. Then we have the whole drama about what you do with their stuff. But this wasn't a long exposure to a possibly COVID-carrying tenant. This was, it's a brief in and out. In the city, we got a little luckier because we had a good presiding judge there too, Judge Burleson, and he stopped all evictions at the beginning, but every month I would have a call with him and I would kind of negotiate, like a later curfew, right? It was like, I'm a teenager. How about 11 o'clock this week, Dad? And how about unlawful detainers this week? How about commercial evictions? How about if you let us start doing 441s? And we got to the point by the end of the first summer where we were pretty much back to normal in the city, except we were still doing all our dockets on WebEx, which was pretty horrifying. But WebEx and Zoom court was fun because you had this, Hollywood Squares or Brady Bunch full of faces on the Zoom call, and the judge is trying to keep order, but he can't have the bailiff throw them out because they're on TV. The judges mostly figured out as they went along that they could mute people, but people were doing anything on these calls. People were yelling at their kids, they were drinking, they were smoking, they were in the bathroom, they were in various states of undress, and that was just the lawyers. Then there was the tenants. People driving. That driving thing really seemed to bother judges. I think they didn't want anyone to have a car accident in their courtroom. They would yell at people driving. But fortunately, we're pretty much past that now. We've gotten some good out of it because sometimes I can get the permission of the court to have a witness appear remotely. So if I have a client who is out of town and has property here, they can sometimes be approved to appear remotely, so they don't have to fly in for an eviction hearing or that kind of thing. And we do a lot of motions where there's just attorneys remote. I always prefer to see my smiling face in person, but the remote stuff works sometimes. It's hard for me sometimes because I'm supposed to be in 3 different courtrooms and one's remote and the other 2 are in person, and I really don't want to run back and forth to my office. But in some of the courthouses, I know where there's a friendly computer that I can use and appear on my remote and then go to my in-person. So let's talk a little bit about what's changed since the pandemic. One of the big things that happened during the pandemic, in addition to being stopped from doing our work for a while, are you gonna make it so I don't kick that anymore? Thank you. One of the big things that happened during the pandemic was rent relief. Did anybody take relief money? It's okay. You can say that you did that. I mean, I got a PPP loan. You know, me and my people couldn't go to court. We weren't making a lot of money for a while there. And I wanted to keep all my folks getting their paychecks, getting their health insurance, you know, and that kind of thing. I didn't want anything to happen to Chris or Christine or Heather or Carrie or Letitia. You know, I wanted everybody to be able to go on. So no shame to me if you as landlords participated in one of the various rental relief programs. The problems were that the tenants wouldn't apply until the day before court, or I'm leaving court today and I'm gonna go apply for it. Well, that was not helpful. The county rollout, St. Louis County's rollout of the SAFER money was horrible, just horrible. They paid $3 million to some internet company in California to set the website up, and it was really months before it was running smoothly. It was awful. I hear that there is still some rental relief money out there. Apparently there's some in Kansas City. But I think the downside of the rental relief money is that a lot of tenants think they can still get that. And we see people that are being referred to us for eviction that have $20,000 or $30,000 in prior rental relief money that they've gotten that was paid for them. And now they've run up months more of rent. And they think they're gonna get rental relief money again. It's not necessarily there. We are pretty much back to 211, you know, United Way, St. Patrick's Center, St. Vincent de Paul, the Urban League, those kind of things. But getting through the pandemic changed a lot of things with respect to the way the courts view tenants. Missouri law is pretty pro-landlord. A landlord-tenant action under statute has to happen pretty quickly here. And there's not a lot of defenses. If you haven't paid the rent, you're probably gonna either pay the rent or you're gonna get evicted. However, judges have gotten, in many cases, more tenderhearted towards the tenants, or at least more cognizant of giving tenants information about how they can get help. And this works in a couple of ways. One is referring them, and a lot of courtrooms have flyers or things posted on the backs of the benches or things on the bailiff's table that can be given to a tenant that give them resources where they can get rental assistance. I don't really care about that so much. The other thing that they have is often a list of the places that do representation of tenants at no cost to them. Have any of you seen those in court? They'll list like legal services, Arch City Defenders, New Covenant. They used to list EHOC, but apparently EHOC's, some of EHOC's people were maybe doing something funny with the books, so they seem to be out of business at this point. They're also maybe from time to time a referral service through the Bar Association to get pro bono attorneys. And then the big one that Amber referred to in that very nice introduction is the tenant right to counsel in the city of St. Louis. And I can tell you where they're getting this from, at least within our state. They're getting it from Kansas City. Kansas City has tenant right to counsel. What this means, of course, anybody has the right to get an attorney if they pay them. You can have me, you have the right to have me if you pay me. But that's the problem for the tenants is they need a free lawyer quite often. And in Kansas City, they have tenant right to counsel. And every Monday, they open the phones for the tenants at a certain time in the morning. And they only take like the first 10 or 12 cases. So the city of St. Louis, which is kind of being run by socialists now, as far as I can tell, decided to pass tenant right to counsel here. And they have $5 million in old pandemic relief money. Personally, as a city resident, I think they should have a functioning 911 system, a reliable water supply, trash service, and a fully staffed police department before we get onto these extras and frills. But okay, they allocated $5 million for this. And we kind of laughed when we heard that. We're like, $5 million a year? No, it's $5 million over 4 years. That does not buy you a lot of lawyers. Have any of you done your own eviction in the city? Gone to Division 28 or 27 on a Friday where they have pro se landlord day? Well, that's just a small drop in the bucket. We have evictions every day of the week in 2 courtrooms in the city. I mean, there's hundreds, if not thousands of people a week getting evicted in the city or having a case brought against them. $5 million is not going to represent all those people. So first of all, before you panic about right to counsel in the city, they have to be picked, and they're probably going to do it. The only pro bono legal agency that's willing to do it is Legal Services. And the city is still fighting with Legal Services about how they're going to do it. Because Legal Services, the city has said, we want you to represent all the tenants that are being evicted. And Legal Services has said, you're insane. We cannot represent that many people. We'd have to hire 100 lawyers, and so we're only going to do a few a week. So they're still talking about that. By the way, those of you who have been following this may know that that's supposed to go into effect July 1st. And the ordinance mandates that the landlord or their attorney give a notice to the tenant being evicted of how they can contact the right to counsel representation. Well, they're not going to be in place by July 1st. Watch your website for your group, because as soon as it gets in place, I will email that notice to John so that you guys can download it and furnish it to your tenants that you're going to be evicting in the city. And I think it's going to be a very small percentage of tenants who will actually get the right to counsel. First of all, half the tenants are ghosting us as soon as they quit paying the rent. They're never going to come to court. You're never going to hear from them again. They're not going to return your calls. And at some point during the process, you're going to find the property abandoned. Is this a movie you've all seen? Right? Okay. The ones who do try to get the right to counsel are going to have to get through on the magic number quickly enough to get one, and that's going to be very few of them. However, if you are doing your own evictions in the city of St. Louis, and the tenant gets a lawyer, and they could do that now even before right to counsel, because they could go to Legal Services, Art City, New Covenant, or whatever, and do it. You probably do not want to represent yourself. At that point, you want to reach out to an attorney. And there's several of us who do this, who do good jobs. I'm the best, but there's several of us who do this. Am I right, Herman? Yeah. There's several of us who do this, and for those of us who do a lot of it, we do it on a volume basis. It's not that expensive. So it's not going to be like a fancy house payment. It's not going to be that bad to hire us. Or at least call me and let me talk to you about it. And let me tell you what one of the big pitfalls is if you're representing yourself. If you're using the forms in the courthouse given out to people who are unrepresented, what we call pro se, to file an eviction, those forms are not compliant with the law. So the court is going to tell you, here's the form that you use. You're going to fill out that form, all well-behaved and innocent, file it, and a legal aid attorney is going to come along and say, ha, you filled out the form wrong and that form is defective and I'm going to move to dismiss your whole case. Chris was in court this morning on one like that, where the person started out representing themselves, they got a Legal Services attorney, and they just didn't have, the form just doesn't have the right boxes. Because it used to be, back in the day, when we filed a regular rent and possession, regular eviction, we could only sue for rent, possession, and court costs. Then in the early 90s, they did a massive overhaul to the rent and possession statute, and they said now we can ask for rent, possession, court costs, and other fees like attorney's fees, late charges, bad check charges, provided there's a lease and they're provided in the lease. We can still not ask for physical damages. However, part of that statute says you can only proceed to evict the person, to physically put them out for rent and court costs, not for the other things. So the logical extension of that is that you have to itemize those things. so that the court can tell how much is rent, and they know how much is court costs, and how much is other stuff, so they can decide whether or not they can award an eviction or not. Are you guys following me on this? Am I explaining it good? You got me? Everybody good? Okay. They also now require, because of a change in Missouri court rules, that you attach to your lawsuit, any kind of lawsuit, any document that you're relying on in that lawsuit. What is your document in a rent possession? It's your lease, right? So you're going to have to attach your lease when you file the lawsuit, and you're going to have a copy of that lease attached to the lawsuit when it's sent out to be served or posted on the tenant. A lot of people don't know this. I can tell you a lot of lawyers don't know this, and they're not doing it. We, of course, are doing it because we are perfect, but in fact, when we saw all this coming and we knew that the court forms were not right and it was going to be a long process to get the courts to change them, we have our own form now. And I'm happy to share that with anyone, who wants to call my office, I'll send it to you. We have our own form for the evictions, and we have our own form for the judgments, because the same thing is true on the judgment. When you go into court, there's going to be a big table with forms on it, or shelves, those kind of shelves where you can put documents in, and there's going to be a form for a judgment and rent and possession, and it is not compliant with the law. In St. Louis County, they want you to file a second piece of paper in addition to the judgment that does all the itemizations, but they don't tell you that. And it's kind of hidden on the table, and it's not a triplicate form like the judgment is, and you're probably not going to notice it. A lot of attorneys don't. So our judgment form itemizes everything that we're taking the judgment for: the rent, the late fees, the attorney's fees. We have one category that we call utility and other, and I think someday somebody might make us break that out, but we're just going with it now because we're so far ahead of everybody else that we're not getting yelled at by the judges yet. And we itemize that all out, come to a total, add the court costs, and that is our judgment. And that's what you really have to have. Probably a lot of the times you'll get away with not doing it, but if an attorney enters on the other side, they're going to see that right away, and they're going to go after you. They're going to try to do a motion to dismiss and just get your whole case kicked, and then you've lost that court cost, you've lost the time, and you have to start fresh, and the court still doesn't have the right kind of form to help you file it. So what's the message here? Call Kathy if you need these forms. Hire Kathy really is what you should do, but if you don't want to hire me, I understand. I'm a little hard, but it's okay. But get the forms from us. Or go to the court and yell at them. Not really yell at them, that's probably not a bad idea, but go to the court and say, look, why can't we have the right form? Because we know that we need to have these itemizations, and see what they say. What's my phone number? 314-962-1115. And some of you may know my partner, Christine Travaglini. You should ask for her if you have a county eviction, because she does St. Louis County. That is such a busy docket for us that's what Christine does. She does exclusively St. Louis County docket. Chris Bosler, some of you may have met Bonnie, my daughter who used to work for me. Now she has a good job. But Bonnie's husband, Chris Bosler, does my city docket and Jefferson and St. Charles. If you're not sure, you can ask for me. We're all a little hard to catch up with because we're in court a lot. You can also ask for Heather, our paralegal, who is wonderful and who will direct you to the right person or help you with the form or that kind of thing if you need it. Yeah, just tell them, say, I need to get Kathy's firm to evict somebody and my property's in the city. Yeah. And be patient, sometimes we're in court a lot. But we will get back to you. Or email us. And I left big cards up front, along with my sharks. I hope everybody got a shark. Yeah, the sharks. And they list everybody's, I think, direct lines and I hope emails, because sometimes it's a lot easier for us to go back and forth with you by email. When I'm in court, I can't make a call, but I can sit in the jury box discreetly and email people. They both will yell at regular people on their phones, but they'll let us get away with it. Right, Herman? Herman and I were doing that yesterday. in Judge Hearn's division in St. Louis County, playing with our phones. Where's Roger? Roger doesn't like to go to court anymore, he told me. Yeah. So sad, Roger. Yeah. So, we know right to counsel is coming in the city at some point. It's going to be underfunded. It might not be well run. Don't panic about it. But if you are doing your own evictions and an attorney does enter on the other side, think carefully about calling one of us to help you. Also, probably a lot of you know this rule already, but if you are an entity, if you're owning your property or you're a management company in the name of an entity, you have to have a lawyer represent that entity. Now, that rule is sort of in my favor, right? Because it's saying, if it's Roger Wallach LLC and he's not a lawyer, he has to hire me to do his evictions. He would anyway, but I also think that the statute says it can be the owner of the property or an agent. An agency is a very loose category. So if you hire someone to manage your property and your property's in an LLC and you hire someone to manage it, an individual, I think they can represent that LLC and sue for rent and possession. I will tell you that a lot of people disagree with me, and I do better with that argument in outstate Missouri than I do here in the big city. But I do argue against my own interests with respect to that sometimes. I am on the Supreme Court Committee, Missouri Supreme Court Committee. I need to quit answering my phone when they call. And we are studying associate civil justice reform. And this is part of the post-pandemic effort to make the courts more friendly and happy for people who don't pay their bills. For unrepresented litigants, is what I'm supposed to say. And these people, we are outnumbered. It's very sad. There's only 3 of us who do creditor side, and there's like 8 attorneys on this committee who represent people who don't pay, unrepresented litigants all over the state. And some of them are from Kansas City. And that's where all this right to counsel and everything stuff started. And it's the Wild West there. They're getting judges to continue cases for months and do all kinds of horrifying things. So we are fighting this. We're just like Churchill. We're fighting on the beaches. We're fighting on the shores. We're fighting it everywhere. And we're on this committee trying to hold the line so that the rules don't get changed to make it unfair to you. Okay? Does anybody have any questions? Or you want to shoot out a topic you want me to talk about? That's my big update about right to counsel. Anybody got anything? Do I think right to counsel is coming to St. Louis County? No, I don't. I think Sam Page and the county council cannot agree on anything. I don't think we have the kind of extreme left-wing progressives in the county that we do in the city. Did you hear about the bill where they wanted, I live in the city, right? The bill where they wanted to let homeless people camp in your yard and you weren't going to be able to, get rid of them? Did you see that article in the paper where Beavis Shock sued on behalf of the poor people that own the property, and the homeless people have been in a tent with tarps on their sidewalk for 3 years? And okay, imagine that, those tarps and that tent and those homeless people on a corner in Clayton. How long? How long do you think? I think the over-under is 5 minutes. Not happening in the county, that kind of thing. And I think that the right to counsel, I don't think the county has the money. The city really doesn't either, because they lost the earning tax lawsuit and they've got some other problems, but they've got this little bit of pandemic money they want to spend on this. I don't think it's a good priority. And I also think that if they wanted to give $5 million to help tenants, they should just make more rental relief. Because if you don't pay your rent, you're going to get evicted. I don't care if you have lawyers. We have lawyers on opposite side of our cases all the time, and if the people don't pay the rent, they're going to get evicted. And if it's an unlawful detainer where it's the end of the lease or we terminated them for cause, we're careful about those. We have our ducks in a row. They're going to get evicted. So, it doesn't, I don't care how many lawyers you have, bring it. Actually, sometimes it's easier when there's a lawyer if the tenant is extremely crazy, and often the lawyers are more frustrated with their tenant clients than we are even. they might do better off hiring social workers for some of these people, because a lawyer can't help that. Yeah. Do I always represent the investor, or do I represent tenants too? Almost always the investor. Hardly ever a residential tenant, occasionally a commercial tenant. And I'm pretty much the only person in my firm that will do that. To represent a residential tenant, it has to be a favor for a friend kind of thing. I don't do that kind of business as my living. But, you know, if someone that I know that I'm close to, their child is having a problem, or, you know, that kind of thing, I might help them. We don't do it a lot because we do so much representation of landlords and investors and property owners that it just becomes a conflict. So, yeah, that's pretty hard to watch ever. Did you have a question?
I did. It was switching gears away from
That's okay.
the EOI report. Are you familiar with that?
With the what?
The EOI, the beneficial owners.
Oh, is this that new thing we have to file with the feds?
I was going to ask, is it in January of 25? Because that has to be done by?
I think it has to be done by December 31st, at the end of this year, for existing corporations. And Roger, correct me if I'm wrong, doesn't it have to be done within like 60 days if you're forming a new one? Yeah. Yeah. Okay, so the feds, I think this is through FINRA, am I right? The feds have made a requirement that all entities, partnerships, LLCs, Incs., any other entity where you're using a fake name other than your name, has to file this report with the federal government that lists all the beneficial owners of that entity, their percentage, their socials, some other stuff. Herman, do you know more about it?
I felt a judge down in Florida declared it unconstitutional.
Well, I think he did not stay it for everyone. I think the stay is limited to just that case. So we're kind of keeping an eye on that to see if that changes. But right now, I would say technically you still have to file it. We have, I guess, until the end of the year to figure out if an appellate court is going to take it up and stay it for the whole country or not. But the situation right now is you're going to have to file it.
Yeah, I mean, it's any entity that gets document recorded with the state. So it's like an LLC, C corporation, trust with a PIN, it's a state filed entity. It's like a land trust, it doesn't apply. But as you know, when you have a land trust, as a beneficiary, you're an LLC. So LLC is the one that has to file all that disclosure stuff.
Could everyone hear that response? Okay, the information is any entity that has to file paperwork with the Secretary of State of Missouri is going to have to file this if you're a registered entity. And I actually think it might be a little broader than that, but I'm not sure.
For the troublesome Airbnb industry, isn't that how that snuck in?
I don't think it was to do, the question is, was this introduced because of Airbnbs? I don't think it had to do with Airbnbs. We were discussing this before our meeting started tonight. And I think I read that this was supposedly a fighting terrorism. And someone else said they thought it was fighting drug dealers. But the key connection there seems to be money laundering. And I just don't think they're going to get that far with this. And I don't think it's that hard if they suspect someone to look into their corporations and figure it out. It's kind of, without having this extra piece of paperwork filed, it's kind of like plus if you're a criminal, aren't you going to file it falsely anyway? I mean, you're already a criminal. Why are you going to start telling the truth on that paper? Right, I mean, it doesn't make any sense to me. It's just kind of like, the city of St. Louis is saying, we're going to stop anybody that's not within 20 miles of the city of St. Louis from owning any property and renting it out in the city of St. Louis because we don't know who they are. Well, first of all, you're on a deed. Secondly, if it's an LLC or corporation, the Missouri Secretary of State has the paperwork that says who the people are behind it. It's not that hard, and they just want to make it more onerous for landlords. And let me tell you about another group that I'm in, because I'm just, I guess, kind of a masochist. in all these groups trying to fight this craziness. The realtors in the apartment association started a group called the Housing Solutions Coalition when the city started getting really crazy with some of these bills they were going to pass. And we have met a number of times, and we have a lobbyist, Maureen O'Donnell, who's very good. And we have had aldermen come to meet with us, and someone who works for Megan Green, and we have gotten them to moderate some of their positions, and we're saving you some aggravation. It's hard to crow about a success when the success is getting them not to do something, but we have been successful. We got the whole thing with the registration enlarged, so it's like within a 100-mile radius of your property rather than like within 20 miles, whatever they wanted. We got the whole mold thing just stopped once we pointed out that scientifically there are a lot of different kinds of mold. A lot of mold, as you know, is due to tenants for housekeeping, and they wanted to have all these penalties if you had mold in if the tenant had mold in their units. Well, that's not even going to be your fault. A lot of mold is harmless. There's like hundreds of thousands of kinds of mold. So they realized that they were not, going to be able to be successful with that. We got the air conditioning one modified. Did you hear about that? They wanted to make it so that everybody would have, 65 degrees in their whole unit. Now it's just between 65 and 80 in one room is the minimum requirement. Now, most of us know that when the air conditioning goes out, it's because the tenant didn't pay Amarin. And that's what really happens. But so we've gotten some of these crazy propositions moderated. And the whole, letting the homeless encamp everywhere, I think, is also dead in the water. Not necessarily because of this coalition, but because everybody in my neighborhood, the Central West End, said, wait a minute, what? and they decided they needed to back off from that one. What else we got? Yes?
Yeah, I got a tenant.
I have some tenants that were supposed to be out by the end of last month. They're still living in the place. They keep on saying they're gonna move out, so the lease is over with. Yes, I can file eviction, but short of that, they're in the process of moving out. Would you send a letter, or what would you do short of an eviction?
Well, first of all, their lease is over May 31st,
Yes,
and they don't have a new lease.
no,
So first, don't accept June rent,
yes.
because that creates a new tenancy, right? We all know that. Secondly, when you say they're in the process of moving out, is that them telling you that, or are they actually like packing and?
Yeah, they're packing, yeah, and they're moving some stuff already, yeah.
Yeah.
Mhm.
That's a hard one, because, my belief is that everybody lies to us.
Mhm.
And, I go to court and negotiate with these tenants all morning. And even if they're very nice, and I'm nice to them, I'm professional, I'm nice to them. But I'm just assuming they're all lying to me,
Mhm.
And sometimes it's more obvious than others, but I would be looking at things like packing and if they're actually moving stuff out, that kind of thing. We would send a letter
Mhm.
if you wanted us to. I don't know that that would impress someone like that. Have you thought about asking them, but we could try that.
Mhm.
We charge about $150 to do that.
Yeah.
Have you thought about asking them for their new address?
Not yet, but I will.
And maybe confirm with the new landlord?
Mhm. Well, she's moved in with her boyfriend, so that's the new landlord.
Oh, that's the new landlord?
So I don't think, well, but then I can use a thing that, hey, if you want to have your security deposit back, I gotta know where to send the money.
Well, and it sounds like if she hasn't paid rent for June, and it is the 18th
Yeah.
today, she's using up that deposit pretty quickly.
Yes, she is.
Yeah.
Yeah.
And do you know any idea what condition she's gonna leave the place in?
No, not good.
Yeah.
I don't think.
Yeah.
Wait a minute.
What we have done, tell her we'll give her $500 cash once she has everything out of there and the place is clean. And
Cash for keys.
that goes a long way.
Sometimes that works. Sometimes, You know, you don't wanna give them the cash before you have the keys.
When they're out the door and everything's clean.
Right,
I'd like to say something else too. Fortunately, I've only had 2 evictions. You handled it, Christine Travaglini handled them, and they went very well. Thank you.
thank you so much. Christine is very good, very tenacious, very aggressive. We've had all this stuff with the pandemic. We've had a lot of turnover with our judges in St. Louis County. It's been a very difficult few years, and she does amazing. I mean, it's just really incredible how she just sticks in there. She's got our new judge. We have a new judge we really like. Christine has her cell phone already and calls her about stuff. I mean, she's on top of it. It's very good.
I actually have a question, and then I'm gonna hit you, and I think John has a question as well.
Okay.
You were talking today about itemizing, so I got my property back Monday through the sheriff. I have a property manager. We went in and there's just, I mean, it's not trash, but she left a bunch of stuff. Can I send that information to my property manager and get that added into the judgment?
Okay, the judgment that you already took to do the eviction with the sheriff, that's done. But you could sue again for property damage. So first you want to take pictures.
Okay.
You want to itemize and keep receipts for any costs that you have. You know, sadly, a lot of what we see is we get the eviction judgment and we don't even have a way to collect that judgment, let alone file another lawsuit, track the person down for breach of lease and ask for the damages and, you know, that kind of thing. So sometimes it's not worth it.
Well, you gave me some numbers to hunt her down and collect.
Okay.
And then I just realized, so I was getting a ghost bill from the water department, and she has about a $1,200 bill that's still on there. So I called them because it was weird. At the bottom it now had my name on it. So I said, hey, what's going on? You know, this is a rental property. And they basically said, because I'm considered the parent on the account and she was the child, if you will, the bill stays with the house. I had never heard of that. So I'm curious, I assume I need to add that on there as well.
Yes, you should. And don't forget to send your itemization and apply the deposit within 30 days for
Okay.
state law. If you don't have her new address, send it to your property, and who knows what the post office will do this, you know, these
Yeah.
days. But they're supposed to forward it, but you gotta do that, or they can sue you for double, which is completely unfair, but they could. So you
Okay.
gotta do that.
Okay.
Okay.
Yeah, hey, thanks, Kathy. So grounds for eviction, what are they?
Okay,
Talk about
so
one.
the basic one, 90% of our evictions are rent and possession, which means they owe rent. Rent and possession is pretty easy to do in Missouri. You have to have a landlord-tenant relationship. The rent has to be unpaid. I mean, if the rent's due on the 1st, we can sue on the 2nd. I don't necessarily recommend that, but you could. And you have to have made demand for the rent. The lawsuit counts as a demand, but we do recommend that you ask for the rent first before you send it to us, you know, see what they're gonna say or if they're gonna respond or, you know, whatever. And then you file the rent and possession lawsuit, you'll get a court date in 3 or 4 weeks. And if they don't pay the rent that's due as of the day of court, you can get a judgment. If they don't pay it still, after 10 days, generally the judgment's final, we can file for the sheriff to meet you out there and get them out. So that's like 90%. Then there are the unlawful detainers. Unlawful detainers are evictions for cause, or at the end of a tenancy, or after a foreclosure, if you're the purchaser of the foreclosure. If you have, just as the situation we just discussed, the end of the lease, don't accept rent for the next month if you want that person gone. And an unlawful detainer, if the lease ends May 31st, an unlawful detainer can be filed June 1st. The unlawful detainer allows us to collect double rent and double damages. Not physical damages to the property, it's kind of amorphous what they mean by double damages, but you can definitely get double rent. If you want to terminate them for cause, we have to have what's called a material breach of the lease. So it can't be just, I don't like the way he looks, it has to be something significant that they're doing that we can terminate. And we will evaluate the reason why you want to terminate and decide whether we can do a full month termination or a 10-day termination. And then there's the big hammer, that's rarely used, kind of the nuclear weapon of evictions, what we call the 441s, for chapter 441 of the Missouri statutes. This generally requires a crime. We will not file 441s unless you have called the police and gotten a police report. This is for like shootings, drugs. You know, we had one where they were manufacturing fentanyl in a 4-family and there were children living in the other units. You know, just horrifying things. It's a really fast eviction. I mean, the court date's in like 10 days and the sheriff will go out immediately if we win. So there are some lawyers, particularly during the pandemic, who got a little loosey about filing these 441s, and they started losing them, and they made it hard for the rest of us. So we're careful. We have good grounds before we file 441. There's one other kind of eviction that's a little more obscure. It's the ejectment. Ejectment is what you have to do after a sheriff's sale. If somebody forecloses on a property and then flips it to you, and you weren't the purchaser at foreclosure, you have to do an ejectment. And the kind of ejectment that I seem to get is kind of the family divorce ejectment, which is where mom has the drug addict kid living with her, mom dies, the rest of the siblings are done with this sibling, and they want them out, but there's no landlord-tenant relationship, and so an ejectment has to be done to get them out. And a lot of times they want to get them out, sell the property, divide up the estate, you know, that kind of thing, but the one kid is a ne'er-do-well. Or the parent dies and they had a boyfriend or girlfriend living with them, and that person doesn't want to move. Those are ejectment situations. I do a fair amount of them, but hardly anybody else does them. And they're harder because they're circuit court, they're a little more expensive, they take longer.
Could you speak on consent judgments in regards to what we're talking about here?
Well, about half the time in court, the tenant will show up. And if they show up, we try to negotiate a consent judgment with them. Sometimes, you know, based on what we know about the schedule of our judge and when we think we can get a trial setting, we might give them a little bit more than the traditional 10 days just to get them signed to a consent judgment. But the consent judgment is going to be they're going to agree to move or pay within X number of days. Sometimes our clients will give us instructions to do a more elaborate consent judgment that says, if you pay $500 every month on the 15th, plus your regular rent and charges when due until it's all paid off, you know, there's a stay of execution. And that can be a good way to enforce a payment plan, because if they miss any payment, even if it's 6 months down the road, we can have the sheriff put them out.
As a private lender, I need somebody that will review both my deed of trust and promissory note. Is that something you would do?
Yes.
Perfect.
And we also do foreclosures.
Perfect. Love that.
Hi, Kathy.
Hi.
These are probably more questions on the side of what could be in a lease. Is that okay to ask?
Yep.
Or- Okay. So, I understand that there could be a maximum of 2 months security deposit in Missouri?
Per statute, yeah. The exception is you can charge more for a pet deposit.
Okay, well, that was the second part of my question.
Okay.
So let's say 2 months rent equals $2,000.
Right.
1 month, 2 months. The pet deposit then could be an extra $300 on top of the 2,000?
Yes.
Is that what you're saying?
Yes.
Okay, and it can be a deposit, not a fee. It
Yes.
can be classified as a deposit.
Yes.
Okay, and then second question, if a tenant is asking for a radon test, like they've been living there and they just randomly are asking for one, how is that best handled? Should we do it and then remediate it? Is there any liability that would then come back if it is positive for radon?
Is there a reason why they're asking?
She asks things all the time. Like she's constantly, there's always something. It could be that, who knows? She's like the worst tenant ever. She's just hard.
So then when that lease is up, don't renew it.
Can you say that louder so my husband can hear that? He's on Zoom.
When that lease is up, don't renew it.
Thank you.
Yeah.
Hear that, Pete?
One thing when we're talking about leases, make sure that your attorney's fees clause, which you must have if you want to be my friend, you must remember the attorneys. Make sure that it is not prevailing parties. Make sure it's just for you. that the landlord is entitled to collect attorney's fees and costs of collection for any actions brought under the lease. Not prevailing parties, which is, they get the free lawyer and they're gonna threaten to sue you for some BS counterclaim, but you're running the risk that, if it goes against you, then all of a sudden you're owing their attorney's fees too, which are gonna grow to be a lot more than mine are, I can tell you that. And another thing that you want in a lease is a jury trial waiver. Put it towards the end of the lease, put it in bigger font, bold it, make them initial it, but a jury trial is waived for any action under this lease or this tenancy.
Do you guys review leases? If we sent you our lease and
Yes.
say, maybe add these things, that would be something you
Yes.
guys should do? Great.
Yeah.
And you provide a lease as well, your standard, I've seen that.
Yeah, I think Chris has it on his computer.
Yep, Chris has sent me.
Yeah.
Oh, I did have an online question about squatters' rights. Can
Oh,
you talk
yeah.
about that a little?
Squatters, squatters is really interesting, because I don't think the governor has signed this yet, but what? Okay, there's a bill. It was passed by the legislature, and the person could have signed it, I don't know. I haven't seen anything saying that it's signed yet, but we expect them to sign it. And it is giving a way to get rid of squatters that's very similar to a domestic violence order of protection. It's a real fast, streamlined way to do it. I will caution you that it has penalties if they're not really squatters. So this is not gonna be a substitute for a regular eviction of a real tenant, okay? But fingers crossed, it'll get passed, and I will know by the first Friday in August that it's passed, and if it's passed, it will go into effect August 28th, and I will talk about that on our monthly call, okay? Because the governor has until like the second week of July to sign it, and we think he's gonna. I mean, the lobbyists that I talked to and everything thought it would happen.
Why isn't he signing it too?
Well, it won't, whenever he signs it, it won't go into effect until August 28th. I think he's busy sitting other things like appointing judges that we need badly, but, no, I don't know, he probably has a lot of legislation to sign. Actually, maybe he doesn't, because I've heard the legislature was completely dysfunctional this year, but, they did get this one thing done, and we're happy about it, and I like the way it reads, and, fingers crossed it'll get signed and, become law. I think this month and a half that the governor has to sign stuff is just part of the process. And because it won't go into effect until August 28th anyway, yeah. Anybody else? Roger?
Yeah, I know I said I'm looking to not go to court, but I'm still going to court, including on one weird one. Have you ever had one where the tenant was trying to invoke that double my security deposit because you didn't have a walkthrough in 30 days?
Yes.
And I've researched this. It was a little harder than I expected, but I have some thoughts on it. But I just wanted to, for this audience, just to make sure that that's an important thing to do. And
well, you are supposed to do a walkthrough with the tenant. What we recommend is that you send a letter when their lease is ending, telling them, when the walkthrough is. If you've evicted them, you still have to offer them this. If you don't know where they are, send it to the property address. Maybe you'll pick up a forwarding address that way. But just be able to show that you sent it. I feel like most of the time the tenants ghost you on the walkthrough, but if they want to come and do it, fine. We tell them in court to ask the landlord for the walkthrough. Then you have the rest of the 30 days after they've vacated to itemize the disposition of their security deposit and send it to them. Or the law was recently changed. It used to be that the court could award them up to double, and now it's shall award them double. So they're taking away twice the security deposit if they win these. They typically file them in small claims court.
when did the shall change over effectively?
3 years ago, maybe?
Okay, it does say shall.
I lost all sense of time during the pandemic. I don't know when it happened, but recently,
Yeah, I thought
maybe longer ago than I'm thinking, but yeah.
Because I mean, the only cases I could find under it, actually, it still said may. So.
Yeah. It definitely says shall now. I think it's 535-300.
Yeah,
Yeah.
that's right.
Yeah.
The other thing, because someone asked about animals, I thought about this too. There's this thing where I had my first client who has a tenant who has a
Emotional support.
the emotional support dog.
That is the biggest scam.
Yeah, and, I looked into it, I hadn't had a reason to before. It looks like you can't even take an extra deposit for it, and you can't even,
Yeah, it's not considered a pet, that's all exactly true. However,
and you can't charge for it.
however, it has to be, well, with an emotional support animal, it's not the same as the
Well, there's two
service
things,
animal.
right, there's ones that, animals that physically help you, disabled, and there's also just emotional support, but I think this thing reads, it doesn't matter for this purpose.
Well, I can tell you that I won this, they still have to, like, pick up after the pet and not let it poop all over
Oh,
the
yeah.
place, and it can't be bad and that kind of thing. And I had a, eviction I was doing where, EHOP got on the other side and asked for a jury trial, because my poor tenant did not have a jury trial waiver and release. And this mother and daughter tenant were driving this four-family building crazy. And, the attorney for MEHOC was not a thorough person. And so in the middle of the jury trial, I was able to produce video evidence that not only was there this one emotional support animal, so to speak, that was pooping all over the front yard, but there were 3 other animals that were also pooping in the front yard that were all living in this unit. And we had on video, this is like a big Perry Mason moment, right? The daughter breaking into the mailboxes in the common lobby of the building. The jury all just kind of went, and yes, I got my verdict, thank you very much. Somebody didn't do discovery.
Yeah, I guess not.
Yeah,
So, but it sure looks like you have to, the only thing you can do, it does say you can, the only thing you can do, you can expressly ask for proof of, I don't know if it's called a prescription or whatever it is, somebody who has
it's some certificate they
some
printed off
kind
the
of something
internet.
that
I mean,
says you have to have, that you have.
it's some certificate they printed off the internet, it's so bogus, it's such a
Okay.
scam. I had heard some rumor that the feds were gonna review that, but I don't know if that's happening. Yeah,
But meanwhile, it looks like I couldn't advise them to, the only thing I could say is that, of course, the general, I mean, your regular deposit certainly can cover all damages, including
Correct.
damages made by
Right.
that animal. That part's clear.
that is
that's-
true, yeah.
I mean, that's all there is really that I could see, okay.
Okay, let me do one thing on CaseNet real quick. CaseNet opened to regular people on July 1st of last year, by which I mean, rather than just seeing like the docket entries, you can now see documents and everything. And a problem that has arisen with respect to this is that we are responsible for redacting anything that we file on CaseNet that gives private or personal information. And this includes things like names and ages of children that are listed as additional occupants on the lease, social security numbers, that kind of thing. We're good at checking for that, but we're not perfect, and we don't want to get in trouble and file something that has information that should be redacted. So if you could, going forward, don't put socials on the lease. You know, you put 3 children, but don't put their names and ages. If you want to put those things in there as part of the agreement, do it as an addendum, so I don't have to file that when I'm filing the main lease with my lawsuit. Do that and help me out, guys, okay? Okay. Who else has? How late is it? Do you guys want to go home? Okay.
Hi Kathy, I have 2 questions. We have a property manager and these are past, well, one is past, but just to raise it.
They're dead?
They're past situations.
Oh, okay.
But just to raise a question for the, hopefully it's not the future, but as an education.
Okay.
First question, we had a tenant, a lady, she was the only one on the lease. Her boyfriend visited, I don't know how often he was there. It turned into a domestic violence issue.
Yeah.
Where he kicked in the door, damages. I think the property manager did ask her to leave. I think that's like all the sensitive subject in the law, but there was damage. So that's where there was a violation to the lease. I don't know if you can expand upon that.
Yeah, the domestic violence stuff, there are special laws for that. First of all, they have a right to break the lease if they are being stalked or pursued and for their safety. I think you have the right to see that they've filed for an order of protection or that kind of thing, but they can break their lease if they can say that there's domestic violence. They have to pay any charges up until they leave, but you can't hold them to the rest of the lease. You cannot, the reverse of that is you cannot evict someone because they are a victim of domestic violence. Okay, so you can't make her move because of that. She didn't do that damage. It might be, what do you think, Herman? It might be a little shaky to charge that to her. Did you make a police report? I would make a police report, certainly.
They are responsible for their visitors or guests in a way.
Yeah. The twist here is that it's a domestic violence situation and there are extra protections.
I had a similar, excuse I'm losing my voice, but I had a similar, situation like that, where the tenant that was living there, her boyfriend, he kicked the door in.
They like to kick the door in tonight, right?
When he kicked the door in, he was, some kind of way they arrested him immediately, and so they contacted me. And when they contacted me, they had him held in jail. So what I did is type the form up real quick, and I typed it making sure that he was responsible for my door before they would release him.
That's a good plan.
So that's what I did. I took the form to the jail, had him to sign it, and he paid for the door. At that time, he got released.
That's a good suggestion. But yeah, I think the main message here is that domestic violence victims have extra protections under the lease. And I'll try to remember to look that up if you want to call me and find out if you can charge the damage to the tenant. I'm thinking maybe not, but.
And then the second question, have you heard of resident benefit packages?
No.
That's
Should I be very afraid?
Okay, so we did change property managers recently in the city. When we interviewed property managers, pretty much everyone is offering the resident benefit package. The minimum price is $30 up to $45 a month on top of the lease. And so what it includes is renter's insurance. We talked about renter's insurance. A concierge service when tenants are moving in to help set up utilities. It may include furnace filters, which we, having a multifamily complex, we don't want our tenants touching the furnaces. So we don't like that part of the lease. And there's about 10 other items. Some property managers require this. Few make it mandatory, but they still require renter's insurance. So here's my question. If the property manager is requiring it and it's an extra $45 a month and the tenant gets behind on rent, so now they also have late fees and the property manager collects some of the money, can they take their fee first for the benefit package versus the late fees, which we're supposed to get 50%?
I would have to look at your property management agreement. But I will tell you something, if I were hiring a property management company and they said, well, we have to offer this, I would say, no, you don't. You don't. And maybe that should not be the property management company that you pick. And I'll tell you something else. There's a lawsuit that has started right now in several states with respect to this RealPage. Have you heard about that? RealPage is, I don't know if it's in Missouri yet, but it's used in some states, and it's where it's used by big companies, I think, at least initially, and they're getting sued by the Department of Justice because RealPage allows the property management companies to log in and find out what everybody else is charging and show their charges and that kind of thing, and that's antitrust. So for your property management company to be saying we have to do this all the same for everybody, I think is like saying they're not allowing competition in the marketplace. Like this owner doesn't have to be the same as that owner. You can decide, I'm gonna make my rent a little higher because I wanna get better tenants, or I'm gonna offer this package because I think the tenants will like it, or I'm not gonna offer it. But email me your agreement with the property management company and I'll tell you whether they can charge you that, how they can charge it. If they drafted the agreement, I bet they can charge it off the top.
So back to my little pet peeve that she was talking about on the resident package. My personal thing is that I feel that the property managers should not be marketing our tenants and affecting their income stream when we allow them in 3 times the rent or whatever the rent is. And then all of a sudden, the property manager can make this a mandatory accessorized thing and tie it in with our lease.
Put that in your property management agreement, they can't do that, they're
Well-
working for you.
That's what I thought, that's
Yeah.
how I look at it, that we hire the property manager to collect our rents, not to market our tenants. And not only that, you're not giving the tenants the option to either seek their own as a consumer, a comparable coverage or similar.
Right,
You're making it a mandatory using our buildings and our properties and our space to market their package.
well, I think that should be negotiated in your property management agreement with this entity. I don't wanna throw property management companies under the bus, cause I represent a lot of them, but it strikes me that some things in this scenario might be worthy of a report to the real estate board.
See, we agree with that too.
Yeah.
We also feel that if we're providing insurance coverage on our properties against our mortgages or, the property itself, that if they want something like that, they should be having us named as additionally insured on those individual tenant policies. And it should be separate from our lease. Our rents are priority, they're first, that marketing, you sign with the tenants and make it optional for them to seek shopping elsewhere
Yeah,
before making it mandatory.
I agree with that.
All right, thank you. Eric Mason Jr. too.
So I had a tenant, kind of reverse domestic thing. They were both on the lease, but they weren't married, so they were fiance, husband, or boy, male and female, gonna be get married. So they both sign the lease, they move in, and guess what? They break up.
I've seen this movie too.
And so, I don't remember the exact details, because it's like 2 years ago, but they wanna kick each other out, right? Because they broke up. And they're both saying, well, we're on the lease, so we have the right to be there. So they wanted me, the crux was, he wanted me to change the locks on the house so she couldn't get in. And I'm like, well, she's on the lease, so I have to provide a key to the unit. Any advice on that?
Well, if
I
they
mean,
go,
well, let me rephrase it. Any advice on future rental agreements that might be able to handle that better?
well, they're generally both jointly and severally liable on the lease. And if they're both parties to the lease, you are liable to both of them to provide the premises and that kind of thing. So you can't lock one out. The only situation where that is an exception is where there's a domestic violence order. Then you might be able to do it, but you need to see that order.
I just told him, I don't know what to do. Leave me out of it. I think that's what you told me, right?
Yeah.
Just, no, I did actually, because I'm an engineer and I'm trying to figure it out. What can I, yeah, and so that's why I listened to you. And so I just told him, well, somebody better get the rent to me, and I don't care who it is, okay? And I'm not changing the locks because that costs money. I put locks in and they still work.
Right.
If you want to hide the key from her, that's your problem,
Yeah. And they can sue each other in small claims court if they're interfering with each other's tenancies, but you have to still be the landlord to both of them. Okay, guys, so my son and my granddaughter are here from out of town, and then Bonnie and Chris's 2 little children, and the out-of-town grandchild and I are gonna go to the pool tomorrow morning so that I can stuff them full of sugar and give them back. So it's been great, thank you so much. And I'll see you on our first Friday Zooms, except not July, because it's right the day after 4th of July. Okay, but by August, I should know about the right to counsel and about this water bill. Okay? Thank you.
Hey, I think Kathy has one more announcement real quick. If you're interested in a handout on the landlord and tenant remedies, Kathy has some handouts.
Wait, that's it. Sorry about that. I'm Nikki.
all for today.